Greetings, 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 greetings. It is I, King Clifford Jefferson, a senator of Godfrey, the fifth caravan Jew, the son of Folk, the ruler of Jerusalem. I am the reincarnation of King Edgar, the Peaceful, also known as the Vicar or Christ, or Melchizedek, better known as the King of Righteousness. It is November 6, 2024, which is equivalent to the birth year 2974. I greet you in the name of the heirs, successors, the predecessors, the martyrs, the saints, and all those who have lived and died for the preservation of the Anglo-Saxon Berbers' illustrious history. I greet you in the name of my Queen Sister Galveston from the House of Galveston for allowing me to be able to grow in the soil best for my growth, as well as my grandmother and my grandfather for preserving me, a descendant of all descendants, which is information able to give it back to the people based upon that which was preserved for people in lieu of a birthright. So once again, I greet you in the name of all the ancestors. This is part 2, waste, common law of the Anglo-Saxon property. Once again, part 2 of waste under the common law of the Anglo-Saxon property. I'm gonna pretty much reiterate and illustrate what it is we talked about yesterday, but go a little bit more in depth. Okay. All right. Concrete information. I hope our advocate is watching as well, or will be watching, inshallah, as well as all those who are of the nations who were split apart as a result of just wasted information. Okay. We see it today. Wasted people based upon the wasted information that they received, which is wasted because of a result of it has nothing to do with their prior or their present condition here on this land. Okay? This was the reason why we have incorporated or incarnated or personified in this day of time to deal with that which had been wasted for all this time. Without further ado, let's get on with this marvelous lecture. If any questions, please leave them in the chat, as well as all those who are willing or would like to participate in the online conversation. No matter what school of thought you're in, please reach out to Archbishop Belmont from the House of Belmont and inquire, as well as, once again, this is based upon us coming together and unifying, all right? Unifying based upon something that was preserved for us to unify with, all right? So it's very important you comprehend what's being spoken to you today, and hopefully it will resonate within your spirit and give you the ability to be able to morph into the character that's needed for you to take your place in the affairs of men and women. So with that, let's get started. Waste, according to the common law. Very, very, very important that we understand what it is that we're wasting, okay? What it is that we are wasting as a people, okay? We have everything we need to save ourselves. Everything, all right? Even though Jali said, take what I gave you and save yourselves. Okay? And that little small pamphlet, he told you, take what I gave you and save yourself. But a lot of us have not examined the whole pamphlet or applied what the whole pamphlet say. That's with anything, any type of rules of engagement based upon the law governing the citizens based upon their residency or domicile, representing their reason for even being on the land, whether it's a birthright or whether it's for commercial purposes. All right. It's very important that you understand the term waste. All right. We talked about it yesterday. We're going to talk about it again today and see the associations that the term has with in regards to the conversation we're having today. All right. Rooted in the common law. So the term waste, as part of the common law, has different types concerning waste: personal property, community property, real property, and unowned property. All right. Waste comes in four ways: voluntary, presumptive, ameliorative, as well as equitable waste. Okay. It comes in four forms: voluntary, presumptive, ameliorative, as well as equitable. If I'm saying that word or that term right. I think it's ameliorative. Just look at it. Ameliorative, yes. Ameliorative waste, permissive waste, as well as voluntary waste and equitable waste. All right. And that term waste involves not only uh, uh, property law, whether real property, personal property, community property, or unknown property, i.e., what we call unclaimed property. Bonner, Baker, Tina. There's also those two terms dealing with acquisition, gifts, adverse possession, deeds, conquest, discovery, ascension, lost, mislaid, abandoned property, treasure trove, bailment, license, as well as alienation. All right. Estates and land is associated with allodial land. Fee simple, fee tail, life estates, defeatable estates, future interest, remainder, which involves future interest or reversion, concurrent estates, leasehold estates, condominiums, real estates, and land tenures. Okay? And conveyances as well. Bona fide purchase, tourist title, strata title, deed registration, estoppel by deed, quick claim deeds, mortgages, equitable conversion, action to quiet the title, meaning clouding of the title, or escheat. All right? All these terms are relative to the term waste under the common law. Future use control, i.e., a future interest, restraint on alienation, rules against perpetuities, rules in Shelby cases, doctrine of worthier of a title, non-possessory interest, liens, easements, profits, usufruct, covenant, equitable servitude, relationships to anything that is associated with rights governing real property, personal property. That will be fixtures, weights, partitions, practices without a license, property rights, mineral rights, water rights. That will be reparent or littoral rights. Reparent rights means concerning property on that sits between a body or border of water. And then you got littoral rights, which it's the same thing, but large body waters such as oceans, seas, etc. All right. Lateral and subjacent support, assignments, Nemo dot, quit plantor, conflicts of property law, black acres, and security deposit. That all deals with what we call a radical title. All right, overseas territory. This all comes under or falls under what we call contract law, tort laws involving wills, trusts, estates, which also subject to what we call criminal law as well as civil, based upon evidence, and it all falls under the category involving either law or common law. Okay, very, very important that you understand that. Let's just look back in the history of New Jersey. All you scholars need to be here today. New Jersey Provincial Council, His Majesty's Council, His King's Council, okay, based upon the government that existed at this time when the colonies were birthed, all right, under a temporary or ceremonial government. They're now called states, they're really called colonies. His Majesty's Council for the Province of New Jersey, now called the Legislative and the House of Representatives, was the upper house of New Jersey legislature under colonial rule until it was replaced by New Jersey Legislative Council under New Jersey's Constitution of 1776 under the Common Law, Article 22, as well as the provisions set forth based upon the reconciliation with the Crown of Great Britain. That's Article 23. Read it in its entirety. We look in the box. The structure of the polity and the length of term of the polity was indefinite, okay? Under the authority of the Crown, which territory, which their corporate domicile, corporate residency was in either Perth Amboy or Burlington, okay? It was called an itinerant court. It was a moving government, okay? It was a moving government. So the Crown government was based upon the laws of the government and governing the land. So if the land is not being governed by the laws of the land, then that's the waste. That's waste of not just the property, but the laws governing the property, all right? Which is based upon the statute. We have the right not just to return to the property, but have be paid triple damages as a result of that, all right? So since the Provincial Council was established in 1702 upon surrender by the proprietors of East Jersey and those of West Jersey of the right of government, the body of politics, to Queen Anne, a Scottish queen, Anne's government united the two colonies as the province of New Jersey, a royal colony established under a new system of government. The instructions from Queen Anne to Viscount Cornbury, the first world governor of New Jersey, outlined a fusion of power system which allowed for an overlap of the executive, the legislative, and the judicial authority. It provided for a bicameral legislature consisting of a council and a general assembly. You call that your House of Representatives. Basic understanding of America's political science. On December 6, 1775, Governor William Franklin prorogued the New Jersey legislature until January 3rd, 1776, but it never met again. What did William Franklin prorogue New Jersey legislature about in 1775, December 6th? That was based upon the two-road speech that was a result of the Continental Congress not only opposing the laws of the king, but breaking away from the king's government, i.e. under the crown, okay? We must comprehend what's being said to you. On May 30th, 1776, Franklin attempted to convene the legislature, but met instead with an order from the new government that was established under the New Jersey Provincial Congress for his arrest. On July 2nd, 1776, the Provincial Congress approved a new constitution, and on August 13th, the new legislature was elected, with the appointment Provincial Council being succeeded by what we have now, the New Jersey Legislative Council. One second, hold that thought. Sorry about that. So under the New Jersey Provincial Council, it states that the composition of New Jersey's Legislative Council deriving their authority from New Jersey Provincial Congress, deriving their authority from New Jersey Provincial Council, which was a fusion of power under the Crown, called the King and the King's Bench. The Provincial Council consists of 12 members appointed by the serving at the pleasure of the British Crown, with the exception of resignations and those being removed for cause. Councillors often served for life. The former province of East and West Jersey were reorganized as Eastern Division and Western Division, i.e. Burlington and Perth Amboy. Respectively, of the province of New Jersey, councillors were appointed that 6 would come from each of the 2 divisions. In practice, however, that would not always follow. All right. Very, very important that you understand that. All right. So key points. It said William Franklin prorogued the New Jersey legislature until from December 6, 1775 until January 3rd, 1776, but it never met again. Instead, William Franklin was arrested. William Franklin was the illegitimate son of who? Benjamin Franklin, which takes us to the article that we visited yesterday in yesterday's lecture, okay, which we'll go to right now. Article from the Jefferson Monticello, Divided Loyalties, Benjamin Franklin and William Franklin. We know loyalty has to deal with oath of allegiance. All right? That's a pledge. Oath of allegiance is associated with a pledge. Okay? We must understand that. That pledge or that allegiance still lies today. Back in Article 22 and Article 23, honoring the common law of the land, which was the common law of England. Okay? The common law of England. That was overthrown with the arrest of William Franklin and replaced with who? William Patterson. William Patterson was not only the Attorney General, but also the governor, a senator, and a governor of New Jersey. Okay? Which is very important. So all those who watch this lesson, write that name down. William Patterson. He was also a judge. Okay? This era of good feeling between father and son would come to an end with the advent of the American Revolution. And Benjamin Franklin, sometimes referred to as a reluctant revolutionary, hoped at first that differences with the British could be resolved. When he did join the revolutionary cause, although he was all in and pursued goals of freedom and liberty with vigor, he expected William could be persuaded to do likewise. Had William always followed his father's lead before? We will almost ask ourselves that same question. This time, Benjamin will be bitterly disappointed. In August 1775, William traveled to New Jersey to convince William to join the rebellion. He told his son he would be accepted with open arms by those opposing the king, all right, and could easily win a generalship and the army formed under George Washington. William refused, remarking that if his father was determined to set the colonies on fire, that's the motto for Rutgers University, on fire, has also make reference to Malachi 4:2 and Matthew 13 verse 43, which we read in my last lecture. You need to revisit that if you didn't had a chance to go over that interpretation. It says in August 1775, Franklin traveled to nowhere but New Jersey to convince William to join the rebellion. He told his son he would be accepted with open arms by those opposing the king. He could easily win a generalship, and the army formed under George Washington, the first president of what you call the United Colonies. William refused, remarking that if his father was determined to set the colonies on fire, he trusted that he would take care to run away by the light of it, i.e., the light that was shining in the west, i.e., the truth that would come to the west that was undermined, that was covered up or wasted by those who knew the history but did not tell those where the history pertained to. So it's very important that you comprehend. As a loyalist, William believed America's best chance to succeed lay in remaining with Britain, i.e., under the body of politics of Britain. Not those who were sitting and governing the body politics, but the body of politics as it originated, okay, by the original heirs, okay, who were the English, because apparently they were not the English. He also believed most Americans would not support the rebellion. William's break with his father became very public with his two-row speech to New Jersey legislature on January 13, 1775, urges them to refuse to endorse the newly formed Continental Congress and take the road to prosperity as part of England rather than the road to civil war and anarchy. His efforts were to no avail. That's very important that they use that word, civil war and anarchy. Okay? Civil war and anarchy. We know that William Franklin, the illegitimate son of William Benjamin Franklin, was replaced by William Patterson, okay, which was at this time the Attorney General, okay, then became a senator, and then he became the governor, okay. So what does William Patterson have to do with the two-row speech as well as William Franklin's plea to the founding fathers not to take the road to anarchy or civil war because it would end with fire for them, okay? Contrast or opposed to perpetuity as well as prosperity being a part of England, okay? Not Great Britain. They specifically used the word or the term England, okay? Why did they do that? Let's see. Who was William Patterson? Let's go to the case first. Back to the case. Because a lot of you might not have caught it yesterday. All this is involving the incorporation of the statutes involving the Plantagenet kings, Edward I, descendant of Henry III, the son of John, the son of Henry II, the son of Godfrey, the fifth Caliban Jew, son of Folk, the ruler of Jerusalem, which apparently was right here in the Garden State. All right? Jerusalem was right here. All right? This application concerns waste, all right, under the term the common law, under 2A65-3, which is still the statute in this present day, as ordered by the Governor William Patterson, who overthrew the crown, but still was governing by the laws of the crown, which was nothing more than what? They once said, the common law of England. Judge Superior of the Court, Mark A. Sullivan, qualifies it. This application concerns the continued viability of New Jersey statute annotated or New Jersey revised statute, either or, because we know that the annotated was amended from the revised statute, which was originated from the legislative amendment, which was derived from the Constitution. The application concerns the continued viability of that statute 2A65-3 and awarding a landlord treble damages for the waste committed by a tenant. The statute is in question provides that a civil action may be maintained in the Superior Court against a tenant upon a finding that waste has been committed. Treble damage shall be asserted as assessed or granted, and the defendant shall lose the thing or place wasted. This is what you call foreclosure. Foreclosure. That's what that's called. Everybody know what foreclosure means, right? Foreclosure. If you don't, let's look at it. You can go on right now on YouTube and pick any channel that you choose to enlighten yourself with, and none of them will come close to our channel. Not one. Not one. Foreclosure is a legal process in which a lender attempts to recover the balance of a loan from a borrower who has stopped making payments to the lender by forcing the sale of the asset used as the collateral for the loan. This is called adverse possession. Okay? Adverse possession. Y'all better remember that word because a lot of y'all gonna use y'all property as a result of foreclosure. Okay? Foreclosure, when you go around to our communities in the hoods or in the project, etc., where you see signs for auctions as a result of foreclosure process for failure to pay that easement. Easement is a use of property that you don't own as a result of the encumbrances, which usually results in some type of lien, i.e., taxes. That's called an encumbrance. Okay? Easy, knowledgeable, sustainable facts. Formerly, a mortgage lender, mortgagee, or a lien holder obtains a termination of a mortgage borrower, mortgager, or equitable right of redemption, either by a court order or by operation of law after following specific statutory procedures. Okay? This is very, very, very important. All right? Very, very important. Let's see. Usually, a lender obtains security interest from the owner, not an equitable interest, but a security interest when the owner who mortgages or pledges a asset like a house to secure the loan. If the borrower defaults and the lender tries to repossess the property, courts of equity can grant the borrower equitable right of redemption. If the borrower repays the debt while the equitable rights exist, it is a cloud on a title, and the lender cannot be sure that they can repossess the property. When there's a cloud of title, there's an ambiguity in who actually owns it. Okay, there's a defect in the title. Okay, this is the whole parable about Jesus coming in the clouds. All right, that's what this parable is about. Therefore, through the process of foreclosure, the lender seeks to immediately terminate, that is, literally foreclose any future sale, use of, the equitable right of redemption and take both legal and equitable title to the property in fee simple. Okay? Fee simple only, not allodium. So that's how you can take your property because fee simple is not based upon some type of birthright, based upon some type of inheritance. Fee simple is an act by way of some type of subfeudation. Okay? The selling of the land for commercial aspects. All right, very, very important that you understand that. All right, so we know what foreclosure means. Let's go back to the case law. Bird versus Haney, a 1999 case, and that's in landlord-tenant court in 1991. Okay, in New Jersey, in the Monmouth County, and they're making reference to this modern-day statute 2865:65-3, which goes all the way back to the beginning, going back to the Statute of Marlborough. Okay? The Statute of Marlborough, also called the Statute of Marlborough. Okay? Or Marlborough. Let's read it. A civil action may be retained under 2A 65-3. Okay? Under this statute right here, an action can be brought forth by any person who has a superior claim over either a landlord or a tenant based upon waste in the property, which comes in four ways: ameliorative, equitable waste, ameliorative waste, presumptive waste, or what we call voluntary waste. Okay? All right, so this application concerns the viability of that common law or the law governing waste under the common law under the new amended or what you call amended or supplemented statute. Okay, 2A:65-3. And the language of it says that a civil action may be maintained in the Superior Court against a tenant and upon the finding that waste has been committed, trouble damages should be accessed or granted, and the defendant shall lose the thing or place wasted. That means that you can be ejected off the land. All right? You can be ejected from the actual property. That's called foreclosure. All right? Foreclosure process. Although the genesis of the statute dates back to England, when the Statute of Marlborough was enacted in 1267, there was little recent precedence on the subject. Okay? Why? Because the people actually living at that time were those who created the law. This was the Plantagenet descendants called the Yorks and the Lancasters. All right? So it's not far as they want to think, because that law that goes back to 1267 was incorporated in that statute back in what they call 1790. Okay? 1790, the New Jersey Statute Annotated 2865-3. It's very important that we qualify this. All right? In 1950, the United States District Court for the District of Delaware ruled that New Jersey courts didn't apply the statutes of common law actions. That's why there's no precedence based upon that statute of Marlborough, because they did not apply the common law to actions concerning waste under the common law. You see what I'm saying? And therefore declined to award trouble damages to the owner based upon the subject matter was based upon some property concerning the movie theater. All right? The within action in common law claim for rent and intentional damages by a plaintiff landlord against his former tenant, defendant is in default for failure to appear. At the proof hearing, plaintiff requested trouble damages pursuant to the above statute, which he found in the Department of Community Affairs, choose and renting pamphlet. So that means by default, okay? When a party doesn't show the answer to a claim brought forth by way of the subject of waste under the common law of England, damages can be awarded, treble damages can be awarded, as well as an ejectment for failure to answer the claim. Okay? We must comprehend that. That's basic knowledge of court proceedings. Were the court to simply follow the Fox case, treble damages arguably would not be permitted. The decision in the Fox case, however, was based upon decisions involving in the Chancery case, Kinley Corporation versus Iceland type. What is that? Excellent type, pardon if I pronounce it wrong, which was a Chancery case, which in that case, Vice Chancellor Bigelow wrote in the case on page 460, this was his dissent. The section of our revived statute 2A:65-3, on which complainant relies on, is a relic from the Middle Ages taken from the statute of Gloucester by Edward I, a Plantagenet king, son of Henry III, son of John, son of Henry II, son of Godfrey V, Count of Andrew, son of Folk, ruler of Jerusalem, i.e., governed the territory which is in question right here, the state of New Jersey. Okay? The state of New Jersey. Governor Patterson, you hear that? Followed the statute of Gloucester and other ancient English statutes and drafted an act for the prevention of waste, which was passed by our legislature on March 17, 1795. Okay? 1795. We must understand who this Governor Patterson is, i.e. William Patterson, at this particular time. Okay? He goes back to the overthrow of the government back in 1776, and his character still is still around. His statute has retained a place in our hooks, and with minor changes now appears in Title 2A of Revised Statute, Article 1, Chapter 79. Do you hear that, y'all? So we must understand who is this Governor Patterson. Who is this Governor Patterson? All right? Let's find out. Let's go to Kinlow Court versus Iceland type. All right? And get a drawing from that case. We talked about this case yesterday. We're going to talk about it again today because a lot of it just went right over the majority of those who watched that lesson or viewed this lesson or will be viewing the lesson in regards to comprehension. All right? Chancery Court, not of an appellate court, not of the Supreme Court, not a district court, but this is a Chancery Court of the state of New Jersey, just like the Special Civil Court in the state of New Jersey in 1946 and in 1999. And both of them are actually dissenting on the same points which are in question upon common law understanding of waste versus upon voluntary, presumptive, equitable, or ameliorative, if I'm pronouncing it wrong, ameliorative waste. Okay? In all four cases, treble damages can be warranted, as well as foreclosure on the state of New Jersey for not doing what they were supposed to be doing based upon those four definitions. All right? It's in the statute. All right? They can be raised as parties in a defense based upon the claim brought forth by a plaintiff. We're going to prove it. It says, Bigelow, Vice Chancellor, complainant owns premises in Belleville, which we're talking about real property, which are in the possession of a defendant. We're talking about a tenant on a lease for a term of years made by a complainant and predecessor in title. So this means a predecessor who has an interest in it based upon the conveyance of it to a descendant, i.e. an heir, okay, who's able to bring a claim based upon 2A65-3 based upon an issue in regard to waste, all right? The bill charges that the defendant has failed. This will be the state, y'all. The state of New Jersey or the state of any state within the United States has failed to keep the demised buildings and repair based upon where the Anglo-Saxon Berbers live, i.e. those who are classified as poor people, okay, or wards of the state, all right? They were obligated to make sure that we were left well taken care of, all right? A decree is prayed for that the defendants pay thrice the damages to be assessed for the waste, and that defendants shall lose the premises and the tenancy be terminated on the filing of this bill. Council moved that the writ of waste issue pursuant to the revised statute 2:79-3, which was replaced by the waste under 2A65-3. All right. How we know it? Let's see. It says, any person may have a writ of waste out of chancery against any person holding by dower, courtesy, or otherwise for life for the terms of years or other term, and well as against a guardian, i.e. a trustee, i.e. an administrator of an estate. Okay? And whoever should be convicted of waste should lose their thing or place wasted and should be liable in thrice the damages assessed against him by a jury. All right? Or not. It can be just by a judge. Summary judgment. Section of our revised statute. The section of our revised statute, okay, on which complainant relies is a relic of the Middle Ages taken from the statute of Gloucester passed by the Plantagenet King, Edward I. This is in 1946. We didn't even talk about the one we just read in 1999. And it said this statute, William Governor Patterson followed the statute of Gloucester from 1275, as well as from 1260. What was the one from Statute of Marlborough, 1267, all right? As well as the one from 1287, the Statute of Westminster. Governor William Patterson followed the Statute of Gloucester and other English statutes, i.e. the ones I just mentioned, and drafted an act for prevention of waste, which was passed by the legislature March 17, 1795. Okay, his statutes has retained a place in our books, and with minor changes now appeared in Title II of the revised statute under Article 1, Chapter 79. It goes on to say, it was the principle of the ancient English law that no action could be maintained in the King's Bench or Common Pleas without the sanction of the King's original writ, which issued out of Chancery, as the Officina Justitiae, Officina Justitiae, pardon if I pronounced that wrong, and which gave to the law the court jurisdiction of the cause. That's how the court established subject matter jurisdiction. The writ ran in the king's name and directed the sheriff to command or reeve to the defendants to appear in the king's bench or the common pleas, as the case might be, there to answer the complaint, which was briefly stated in the writ. If the defendant defaulted or failed to obey or failed to appear, process known as a judicial writ issued out of the law court to compel his appearance, bring forth that body, habeas corpus, in which a several specimens of original writs, writ of habeas corpus, writ of mandamus, writ of circulator, all these were prerogatives of the crown, as we see here. So we see one from the Chancery Court and one from the Special Civil Part dealing with issues regarding tenants and landlords. We know landlords got their authority from the crown. All right, we must comprehend the unification I'm trying to bring to the clarification of what it is that we've been misguided by way of those who mislead us based upon their interpretation of what it is that they say the law is. Okay, we must comprehend that. So this in regards to the revised statute 2A:65-3 by bringing forth a claim for waste, all right, and being paid treble damages as well as the return of the property by way of either injectment, reversion, remanagement, or any other process that deemed fit by way of what we call the course of common law. All right, so let's see. Let's go to William Franklin first of all. William Patterson. Let's look him up because he incorporated the laws of our ancestors. The Statute of Gloucester, the Statute of Marlborough, the Statute of Westminster, which is no other than the Donus Condition of Butts, which is from the Plantagenet Crown. In the 13th century to the 18th century, he closed the gap of the precedents, okay? There was no precedent, i.e. common law, but there was citations based upon the Constitution reserving the common law of England, all right, which we can prove. Article 22, Article 23 of the 1776 Constitution, Article 10, Section 11 of the 1844 Constitution of New Jersey, and Article 11, Section 10, Paragraph, Article 11, Section 3, Paragraph, 3 of the 1947 Constitution, preserving not just the common law, but the administrative body as well. Okay? We must comprehend. All right? So William Patterson was an American statesman, lawyer, jurist, and signer of the United States Constitution. All right? He was Associate Justice, United States Supreme Court, and second governor of New Jersey, and a founding father of the United States. Now, remember what William Patterson warned the founding fathers of what not to do. Okay? We have to remember that. All right? Let's look at his resume. Everybody see it? Hold that thought. William Patterson. Not William Patterson. Yeah, William Patterson. It was nominated by George Washington. Okay? Now, they were warned by William Franklin not to oppose the king. All right? It was right to oppose those sitting as kings, i.e. Queen Anne and from King James I all the way to those who succeeded him. All right? They were right to oppose them because they were de facto monarchs. All right? He was right to oppose them, but not to oppose the crown. All right, very important you understand that. William Paterson was nominated by George Washington, which was worn by William Franklin, the son of, or the illegitimate son of Benjamin Franklin, to the two-road speech on January 13, 1775. He was the governor of New Jersey from 1790 to 1793. He was also United States Senator from 1789 to 1790. Okay, but he was the Attorney General from 1776 to 1783. All right, i.e., the Treaty of Paris. Governor William Livingston, all right, was his predecessor. All right, William Livingston was the predecessor, not the predecessor. What's his name? William Franklin was the predecessor of William Paterson. Okay, very important. William Paterson was from the Otter plantation. He was an immigrant who immigrated here. All right, very important that you understand that. All right, he was a Protestant. All right, a Protestant. Why is this important? But yet he took the time to incorporate the laws in regards to those who were protected by the law he incorporated, i.e. the common law, going all the way back to the plantation in the crown who had heirs here who were unconscious about that as a result of their state of servitude, i.e. their status by being incorporated as residents, i.e. employees of the new colonies or the new states, or i.e. the United States. You're nothing more than an employee, okay? You're either employee of the crown or employee of the state. I'd rather be an employee of the crown because the employment of the crown ensures your employment as a citizen, a national to that country, okay? Which has nothing to do with going to work, okay? But it has everything to do based upon the articles of incorporation, based upon the corporate domicile, pursuant to the articles of corporation, which pretty much sets the standard for corporate status, okay? And corporate status is based upon the corporate domicile through your articles of incorporation, which based upon the primary businesses of the corporation that they were established to do. And we're talking about states or colonies at this time, not the crown, because the crown allows incorporations through charters, which can be revoked if found to be based upon fraud, willful or malicious intent, or just violation, just straight treason. All right, we must comprehend that. So William Franklin was replaced by William Paterson, and William Paterson was not only Attorney General, he was also what they said a senator, a governor, and as well as a judge on the Supreme Court. Okay, a judge on the Supreme Court. So imagine why a lot of the problems that we have in regards to due process of law is not being adhered to. Why? Because we ourselves as citizens have wasted the law. One man's trash is another man's treasure. If we gave it up, they gonna use it. Okay. Everybody's using the common law, but they ain't the people that originated from that common law. You have to be English for that. We must comprehend this connection. Okay. So William Paterson was from the Ulster plantation. He was an immigrant, all right? And that resulted from what we call the plantation of Ulster. All right, the plantation of Ulster. Let's look at what that is. Because he's an immigrant, he's a foreigner. He's not a citizen under the common law of England. He's a foreigner. But yet he incorporated the laws to protect the citizens who didn't know they were actually citizens as a result of them not knowing their nationality. Okay, based upon the law of that land, which protects the nationality, contrast to a law of that land that allows for foreigners to now be protected through what we call permanent residency. Okay, difference, because people are now employed to be citizens. What do you think was going on right now? The plantation also was an organized colonization of Ulster, you hear that? A province in Ireland by people from Great Britain during the reign of King James VI of Scotland, and now assumed the first king of England. You hear that? He wasn't no king of England. He was no king of England. For that, you got to go back to Edward I. All right? That's when the anarchy started. That's when the Civil War started. All right? As a result of the claim over the estate. All right? The claim over the estate. We must comprehend that. All this plantation of Ulster in which William Patterson and every other founding father participated in originated from or came as a result of or preceded what we call the Elizabeth religious settlement, all right, or the act of settlement. This was due Queen, what was called King William, all right, another Scottish king. The Act of Settlement is the Act of Parliament of England that settles the succession to English and Irish crown to only Protestants, which passed in 1701. More specifically, anyone who became a Roman Catholic or who married one became disqualified to inherit the throne. So if they are from the Scottish crown who are sitting on the throne of England as a result of what we call the Act of Settlement, the Act of Settlement, and what we call the Supremacy Act of 1534. How many of you know about that? In 1558, because there was two. The one from 1534 and the one from 1558. The one from 1534 involved Henry VIII. All right. The one from 1558 involved who? Queen Elizabeth I. All right. We must comprehend that. All that relates to the Bill of Rights. Okay. Which is where the religious freedom came from through your First Amendment. All right. But the prejudice that precede them all is the Clarendon Act, all right, in 1166, all right, which was the creation of size courts throughout the world, all right, to protect the estates from all the heirs throughout the world who descended down from the Plantagenet crown as regards of the Intel estate based upon heirs who were subject to the crown based upon a beneficiary right through what we call lottery of season, which has yet to take place. All right, if you are not an heir. All right, let's get on with it. All right, let's get on with this beautiful lesson. New Jersey Revised Statute, Title 2A 65-3, which encompasses all the three statutes incorporated, called the Statute of Marlborough, the Statute of Gloucester, and the Statute of Westminster II, which is nothing more than the donors conditional books, which is a statute governing the intel property that were let for heirs, known as part of what we call access to quake. Very important that you comprehend that. Let's see. The same statute of our forefathers is the same statute you see right here on the screen. Under the New Jersey Revised Statute as amended or supplemented, okay, by Governor Patterson, William Patterson, okay? We must comprehend that. A civil action may be maintained in Superior Court against the tenant, and upon the finding that waste has become committed, and treble damages should be assessed or granted, and the defendant should lose the thing or place wasted. That's called foreclosure. This is a process called or result from escheatment. Escheatment is a result of property that's abandoned, called abandoned property, which is also called escheat under revised statute 46 colon 30B1, okay, which only result from interstate, there being no heirs, okay? So if heirs are not there to make a claim of an action of way, then the only person that can do that is the king who represents the heirs as the provincial patriarch, the father of the nation. The father of the nation. We must comprehend what's being said. 2A65-5, same statute governing the same incorporated statutes by our forefathers. It says if any heir, hear this, if any heir maintains a complaint based upon waste and destructions of our property, whether it's by voluntary, permissive, equitable waste, or ameliorative waste. All right. We have the right to bring a claim in the superior courts. All right. And this being done by an heir. The heir also happens to be a king. Any heir may maintain a civil action for the waste or destruction of an inheritance, whether such waste occurred in the lifetime of his ancestor or thereafter. The judgment in such an action should be for the recovery of the inheritance wasted, or if money value, if such recovery is impossible, and treble damages. Where else can we go to for a right to regards to bring a claim? Another statute under the same statute. 2A37-10. It reads, if any waste is done or committed on any real estate which has escheated or made a street to the state, i.e. the state of New Jersey, the attorneys general shall apply to Superior Court to restrain such waste. Any person doing or committing any waste or other trespasses upon such property should be liable and damages therefor, to be sued for and recover in the name of the state by an action in any court having jurisdiction thereof. So that means that if the state foreclosed on property as a result of waste, which actually was caused by them, because of the laws that were actually there prior to them coming in possession of the property that was laid to waste, all right, due to what we call the industrial age. We now, as an heir, have a right to bring a claim based upon the waste, which resulted from what we call trespassing. They trespass. Everyone understand that? Trespass. When you trespass, that's an invasion of privacy, okay? Intrusion of seclusion. We must comprehend that. Why is that important? All right? Because when something exceeds, it becomes abandoned, right? And they got a street act in New Jersey under Title 46. Title 46, 30B1. This chapter should be known as, and may be cited as, the Uniform Unclaimed Property Act. You hear that? This act or this statute or this title governs property that is escheats to the state, the same as mentioned in the case law we just cited based upon the common law citation. Very, very important. Also under the waste Title 2A, which was incorporated by our ancestors, they also have in the same statute, governed under statute of Westminster, statute of what we call Gloucester and Marlborough. It says party to foreclosures actions against trustees or fiduciary. It says here. It should not be necessary in any action to foreclose any mortgage or mortgages to join as parties or parties defendant in any statutory trust or statutory trusting of any interest, right, claim, or title held in or to the mortgage premises by a trustee or fiduciary for the benefit of such statutory trust or statutory trustee. But any order or judgment entered therein should be a binding and effective as though they have been made parties to such action. Nothing in the section should be deemed as indicating that prior to June 14, 1938. So that means that any party in regards to a statutory and what they have an interest in, and a claim being brought in on a claim based upon, as they said, a mortgage, and mortgages results can be reversion back to the original claimant if there's a foreclosure on it for undue rent or undue payments based upon the original agreement, i.e., original contract. We must comprehend that. All right. So that brings me here. Okay. That brings me here. An instrument governing foreclosure. All right. Heirs. In closing, upon the death of a testator, title to real property vests in the testator heirs, even if the will is not yet in probate. Similarly, where a purchaser of property dies intestate. You hear that? Intestate meaning that there are no heirs. If it's interstate and there are no heirs, that means that it automatically exceeds to the so-called sovereign who makes claim to it, which would be the state by bona vacatina. Okay? Which is under the revised statute 46:330B1. But they only oversee it because the crown takes it by right of its jury regalia, its prerogative. All right? That's the purpose of the crown, to take property that's exceeded as a result of interstate. But you need an heir for that. All right? Upon the death of a testator, title to a property vests in the testator's heirs, even if the will is not yet in probate. All right? We're talking about a testamentary will. This is called either voluntary or involuntary exchange. Okay? Similarly, where a purchaser or property dies intestate, the property also descends to the heirs. Okay? It follows that the owner heirs are necessary and proper parties in a proceeding to foreclose a mortgage on a descendant's property. A judgment will bind an heir who cannot be located after diligent inquiry where the foreclosure mortgage publishes notice of the foreclosure proceeding. Remember, you are an employee based upon your residency, based upon that which identify your residency with no other than the instrument provided by the state, based upon the state's residency as a state, based upon their corporate domicile or the corporate residency. And if you carry the instrument created by the state who identify you for identification purposes, which is based upon your residency, that determines that you are just living there based upon your employment as an employee of the state, i.e. a resident of the state, i.e. a citizen of the state, which has nothing to do with you being a national or a foreigner or some country, all right? Pertains to just soil or just sanguineous. We must comprehend that. So it says, upon the death of a testator, title to real property vests in the testator's heirs, even if the will is not yet in probate. Similarly, where a purchaser or property dies intestate, the property also descends to the heirs. It follows that the owner heirs are necessary and proper parties in a proceeding to foreclose a mortgage on the descendant's property. A judgment will bind an heir who cannot be located after diligent inquiry whether foreclosure mortgages publishes notices of foreclosure proceedings. So when you claim to be an heir, when they're foreclosing your property, based upon how they identify you, you ain't an heir. You are an employee of a state, i.e. what they deem as a resident, that therefore is considered abandoning the property. We must comprehend that. All that is governed under New Jersey revised statute or New Jersey statute annotated Title 3B, which deals with administrative of estates. Okay? Administrations of estates. Let's continue on with this excerpt. This is New Jersey foreclosure laws in practice, 2013. It goes on to say, because the heirs are necessary proper parties, it is not necessary to also join as parties to finish the executor or personal representative of the estate. However, joining of the executor or personal representative of the estate is necessary where the state is sought to be held liable for a deficiency. All right? Very important. In such event, a judgment rendered against the executor or a personal representative will bind the beneficiaries of the estate. Very close attention. In the event that a foreclosure mortgage seeks to extinguish the right of someone with a contingent interest in a mortgage premises, the foreclosure mortgages need not necessarily join the contingent holder as a defendant in the foreclosure action. Such contingent holder will be bound by the foreclosure judgment so long as his or her interests were represented by a trustee made a party to a foreclosure action. Y'all better listen. The contingent holder will also be bound by the foreclosure judgment if his or her right were represented by the holder of a vested estate who was made a party. So I am the one who made an interest in the estate on behalf of you as being the trustee or representative of the estate based upon foreclosure, that the process that was done by way of abandoned property, which the state took it. But you only got the right because it was left abandoned. If it exceeded, then that property of escheatment is a jury regalia or right of the crown. Okay? As even says here, going to say that in the event of an unborn contingent remanderment, you hear this? Such as whereas a will divides an interest in property to an unborn children of a legatee, a judgment of foreclosure will be binding upon those persons if a living member of that class is made a party to the foreclosure action, or if the living owner of the estate upon whose interest the class is contingent in name. Hereto, the need to name the holders of contingent interest can be obviated by naming a trustee who represents the entire class. Did y'all hear that? You heard it, but you didn't comprehend it. So let's make it comprehensible for you. Okay? Let's go to point 2A 50-15, as well as New Jersey Court Rule 4-26.3, which is the excerpts governing what we're reading about in regards to claimants, i.e. heirs, bringing the claim on behalf of the entire class as a representative. Let's go to New Jersey revised statute, which governs the administration of criminal and civil justice, which was incorporated based upon what Governor William Franklin did in 1795, based upon those statutes that existed prior to him even being born, going back to the Statute of Marlborough, the Statute of Gloucester, as well as the Statute of Westminster II, which is nothing more than the Statute of Queen of Praetors and the donors conditional bus. All right, let's go on and see what the statute says. To A 15-15 in closing. It should party to foreclosure action against trustees or fiduciaries. It should not be necessary in the action to foreclose any mortgage or mortgage to join as a party or parties, defendants in any. Oh, we just read that. All right. So if we just read this, let's go to the statutes qualifying this. All right. Very important to go to the statute qualifying this. Rule 4:26-3. Representative by presumptive taker. Okay? Representative by presumptive taker. Very, 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 very important. I think I missed one more. Let me just make sure I didn't forget it. Okay, yeah, I did forget one. Before we read this one, let's go to the one we just read. (37-10). Let's go right back here. Queen, you mind warming this up for me? All right. We're going right back to an heir being able to act on behalf of the class as representatives of an heir in regards to Section 2A of New Jersey revised statute, annotated or revised statute, all has to deal with those laws that were incorporated or supplemented by Governor Patterson when they overthrew the crown in 1776 and incorporated in your modern day statute, which is what we're reading right now, 2A-37-10. And this is dealing with waste laws under the common law of England, governing either waste based upon trespass. When you trespass on land or property that belongs to you and then leave waste there, that's even more reason, especially when it's the state of New Jersey, because anything that was abandoned from the Anglo-Saxon Bourbons have now escheated to the state of New Jersey based upon their laws governing what they call escheatment laws under Title 46, 30B1. We just read the statute. So all the property that belongs to us has escheated to the state, and they're just watching it or overlooking it until an heir come back. All right. And how do an heir come back? By bringing the claim based upon you not doing what you're supposed to be doing in it, based upon the four terms dealing with waste under common law, which was what? Voluntary waste, presumptive waste, immemorial waste, and equitable waste. All right. Even if you make improvements to it, we need to make changes to it. Why? Because you're destroying to it. What was a beautiful land when you came here, do your conquest or do your right of what they call conquest or right of discovery, the land was floating like milk and honey, had trees and everything. Now you cut it all down. It's nothing more than what you call a wasteland now. Okay? It's a wasteland. You have laid waste to the land because you have laid waste to the people by laying waste to its laws. And this is the common law of England that was incorporated by William Patterson that we have forgotten. Okay? So if we read it, 2A 37-10 of the common law of England, as should be interpreted, based upon how William Patterson incorporated, based upon the origin of the law he incorporated, going back to Edward I, it said if any waste is done or committed on any real estate, that means any real estate that exists in the United States or the states that make up the United States, being that the land is allodial, and being that no land in the United States is allodial because they have to pay taxes, and taxes come from encumbrances, i.e. what you call fee. Fee means tax, all right? If any waste is done or committed by any real estate which has exceeded or may exceed to the state, we talk about only one state in New Jersey, the Attorney General shall apply to Superior Court to restrain such waste. You hear that? So if the waste came from trespass, which they trespassed and they wasted not the state of New Jersey, but every state, but when they unified, which William Franklin told them not to do. Why? Because it's going to bring fire to the, excuse my friend, I'm going to say it anyway, bring fire to the ass. Any person doing or committing any waste or trespass upon such property shall be liable in damages, therefore, and to be sued and what? Recover damages in the name of the state of New Jersey by action in any court having jurisdiction thereof. Well, the Superior Court of New Jersey got jurisdiction based upon the rules of the court governing the court of New Jersey. Before we go to that rule in closing, let's watch this previous statute, 2A 37-10, right? They sealed their own doom. Administrative Civil and Criminal Justice, Section 2A37-9, a state party defendant to action to foreclose lien on its treated property, service of process. Guess what, y'all? They did get service of process because guess who represented the state? The Attorney General. And the civil case filed on behalf of who? You're represented on behalf of what? The whole class based upon wasting of our property based upon the laws governing our property, which is the common law of England, which they don't follow. And they're moving for dismissal because they're saying that the common law don't exist there. That's not what you see when you go on New Jersey court law and see the origin of the common law based upon the 1947 Constitution, Article 11, Section 1, Paragraph 3. All right? So 2A37:9 clearly says, and we read it verbatim. When any real estate which has exceeded, that takes you to 46:30B1, it's right there under Title 46. 46:3-2 says, the King of England, by deposit, corporate, or person dealing with the inheritance, tenements, land, all things are now subject to the king, and they are taxed to what we call free and common soakers. Why? Because there should not be no feudal tenures because the land is allodial. So if the land is not allodial and there is being activity on the land, that means there is nothing more than feudal tenures based upon the charter, which is nothing more than the Articles of Corporation, which New Jersey has based upon Title 52, other revised statute based upon Article 6, Section 4, parts of Paragraph 6 and Paragraph 4 of Article 4, Section 4. But guess what? Under Section 1 of Article 1, based upon legislator, they are not, in fact, citizens. So guess what? Under 2A-37-9, they can be brought forth as a defendant and action to foreclose on the property that they claim to own when they're foreclosing on the property that the people actually own. Okay? So you notice why we're losing our property because they're foreclosed on it because they claim we owe them for it when actually it's the other way around. All right? It says here in closing, when any real estate which has exceeded or may exceed to the state of New Jersey. Now we can go right now to 46:3-6 and says that the land in New Jersey is allodial. It says it right there. So this is the land that New Jersey has claimed exceeds to them as a result of bona vacatina. So you don't own it. You just hold on to it until I come back as the crown representative or the king's representative for the nation, i.e. the head national. So it says, and I'm going to read it without disrupting in its entirety. Let's read it. When any real estate which has exceeded or may exceed to the state of New Jersey or which prior to such a statement, that has existed or may exist any lien of any mortgage, pledge, or hypothecation in such real estate, the holder of such mortgages, pledge, or hypothecation justification may make the state of New Jersey a party defendant to his action for the foreclosure thereof, whether instituted in a state court and or in a federal court. The state of New Jersey should be considered to be served with proper or sufficient process and brought within the jurisdiction of any such court when a summons shall have been served on the Attorney General of this state, the state of New Jersey being named as the party defendant in such summons. If the Attorney General shall refuse to acknowledge the service of the summons, the physical delivery on a true copy thereof and the exhibition of to the Attorney General or the original summons shall be considered a good and sufficient service to comply with the provisions of this act. And guess who served them? The Sheriff's Department, y'all. The Sheriff's Department served them as a result of the property that is ceded to them as a result of it being abandoned because they took it as a result of interstate when they wasn't supposed to take it. Why? Because it actually belongs to the Crown. And then go to the Crown. Why? Because under the interregnum, the Crown did not exist as a result of the body of politics that was temporarily enforced by way of William Patterson in 1776, when they removed William Patterson from his authority as the governor, which was the head part itself, nigga in charge. Okay? William Patterson. All right? And William Livingston told him, part itself, he became the person head of those who are identified as Negroes. Because prior to that, we was protected because we was not Negroes because we was under protection of the Crown. Okay? We can go back to United States versus Wong Kim Do and see that an Anglo-Saxon of descent does not have to prove that he is, in fact, descendant here in North America as an Anglo-Saxon ancestor. All right. So in closing, it said if the Attorney General should refuse to acknowledge the service of summons, which he can't refuse because they already responded to the complaint filed this year in 2024. So he already got notice that he's being sued based upon what we're reading about here in this statute in regards to the ceded property that New Jersey now have in their possession when originally it's supposed to belong to the king because the land is the lord of. Meaning that you're not supposed to be having it, nor are you supposed to be doing business on the land under feudal tenure. Because feudal means tax, right? And one way of a corporation's business practices is the ability to be able to tax, okay? When you open up business, you get an instrument showing the authority to be taxed, use tax and sales tax by the state of New Jersey. How the hell are you going to get that authority when you never had the authority to do it in the first place? All right? Let's see. So let's go to, it just said, the state can be raised as a defendant when they foreclose on some property that does not belong to them. We know it don't belong to you because the only way you got it is through escheatment, and escheatment is only as a result of interstate. Involuntary escheatment of property that actually was entailed based upon the laws that were incorporated by William Patterson, which was the Statute of Gloucester, the Statute of Marlborough, the Statute of Westminster II, which is nothing more than the statute governing entail estate for heirs. And entail estate is called crown land, which is personified by the crown, which is no other than me, i.e. your king. Okay? So let's go to the statute, which I'm going to use, not just in the criminal case filed in the Superior Court, which is the King Court, not just in the civil case filed in the Superior Court, which is the King Court, but as well as in any case henceforth. All right? Watch the statute I'm going to use on behalf of the representation to be able to bring a claim on the defendants, i.e. the state of New Jersey, as a result of the Escheatment Act. Because let's go here. It says the heir has the right to do so, either under Title 40, Title 2A 50-15 or New Jersey Revised Statute 4:26-3, which we're going to read in closing. Let's read it. Representation by presumptive taker. This is a rule of the court. All right? In New Jersey. Let's read it in its entirety. Representation by presumptive taker. Presumptive is the action of assumption, to assume. And the state can assume, the king can assume, hell, even the attorney general can assume. All right, but not in the king's court, you can't, because the highest assumer is the king. All right. Representation by presumptive taker. And the action affecting property in which any person in being born or unborn has or may have future interests other than life or lesser estate. A lesser estate or a life estate or the state and the feasible is fee simple. Hold your thought. Hold that thought. So this is the courtroom. This is the court rule. It's going to allow us to be able to counter both actions in criminal court and civil court on behalf of me representing on behalf of what has been foreclosed on by people who don't actually own property that they use to foreclose. The actual owner of the property are the heirs that was left in interstate, but as a result of the heirs not being anymore, it became or it ceded to the state of New Jersey. And we know when New Jersey is when land is ceded to the state of New Jersey, it's not there for them theirs to keep. All right, it's just there for them to hold. All right, let's read it. In the action affecting property in which any person in being or unborn has or may have a future interest other than life or lesser estate, which is nothing more than fee simple, or whether it's not known or it's difficult to ascertain who is the person or class having such interest. You hear that? Or if it's difficult to ascertain who is the person or class having such interest, it should be necessary to join as parties to the action only the person or person who will be entitled to such property if the event or contingency terminating all present estates and successive life or lesser estate therein has occurred on the date of the commencement of the action. All right? Of the action, and the judgment entered therein shall be binding upon all person. Okay, so we now know the state can be brought in as a defendant in the action or foreclosure to a person who ain't even been born yet if it affects an estate of those who have died and the estate has resulted in interstate as a result of exceeding to somebody who doesn't lawfully have a right to have it. Okay, you don't have a right to have it. And they don't have a right to have it because they're not citizens, because the only identity that denotes or identify them is a damn driving license, which does not denote to either a citizen or a foreigner. Okay? Because foreigner and citizen is just a term used for status. Okay? And the status of a foreigner or citizens or citizen is either a national or an alien. One of the two. Okay? One of the two. So I'm not bringing a claim here based upon the rule of the court backed by statutory law in regards to trespassing or not just trespassing, but as well as waste on property that don't belong to you as a result of you mismanaging the property. Okay? You're mismanaging the property, therefore an heir have a right to bring a claim and join any party to that claim if they're involved in as a result of them having an interest in that claim that being brought forth by the party who is a representative for the whole class in question. Okay? We must comprehend that. I'm the one that fits that description. Okay? It said that, it also goes on to say that should such conflict exist, the court may, in its discretion, appoint from among the persons then next entitled upon the occurrence of the event of or contingency, one person to represent all persons, whether it being or not, who may claim any future interest in that property. Okay? So this is the reason why understanding citizenship and residency is very important, because the only one that can represent you based upon your status as a resident or a citizen is either the head person in charge, which usually results in your governor, all right, because the governor is head of state, all right, or the president is head of the United States. He's your go-to guy, okay? He's the one who represents if there's been an invasion or an intrusion on the will of the people, i.e. the sovereign people. But the sovereign people in which they're talking about is not you. That's only a 10 square mile radius governing the District of Columbia or Washington, D.C. Any party that to a claim and regarding the state of property being wasted of the United States outside or contract to the United States, that problem has to go to the state itself. Okay? And if it does, that means that you're not a state citizen based upon the meaning of a citizen, having to deal with you being a citizen of that country, having a nationality. Because the only thing you got to prove that you are a citizen is that ID card come from motor vehicle. Okay? Given to you by a state. So that means that the state not only wasted your culture, they wasted your customs, they wasted your traditions, they wasted your laws, they wasted your identity, they wasted your ability to be able to read, write, and learn as a result of your ignorance. Okay, so somebody has to speak on behalf of you. You're a ward of the state. All right, you are a ward of the state. All right. So in closing, aside, what was it called? Aside the more ancestor. This is a right that we have in regards to property that is distributed to the state by way of what we call common recovery, which resulted from freeholders now calling themselves commissioners. And motor vehicle do call themselves the commissioner. All right. So if they wasn't had the word commissioner back then, they should have called New Jersey Board of Freeholders and not New Jersey Motor Vehicle freeholders and not New Jersey Motor Vehicle Commissioner. Okay. Very important you comprehend that. So I'll read this in closing. Asides of morti ancestors. In English law, the asides of morti ancestor mean deaths of an ancestor was the action brought where a plaintiff claimed the defendant had entered upon a freehold, that's trespass, y'all, belonging to the plaintiff following the death of one of his relatives. Okay, and as a result of that, they have laid waste to the land. When our ancestor Edward I of the Plantagenet crown was invaded by Henry VIII and Henry VII of the House of Tudors, who passed it on to Elizabeth I, to King James I, and now their heirs and descendants, i.e. William Patterson, all right, who was also a Protestant. That goes back to the Protestant Reformation of the Protestant Church, which goes to the English Protestant, which you have the English Reformation Day, which is October 31st, which we just had, is results to what we call Halloween, ghouls and goblins, okay? Now realizing that the real ghouls and goblins is the ones sitting up there in your office today, acting as if they're the real Anglo-Saxons, which really originally were the saints and the martyrs that were honored after October 31st, which is November 1st and November 2nd, the honor of the saints and martyrs who died for the cause. All right? So you must comprehend what it is that not just I'm at your king, but those who are not part of the movement are helping, such as Yasmin Hafez. All right, we must understand what it means to advocate. All right, we must understand what it means to advocate. Advocating on the street corner is not going to do it. Advocating up here on YouTube is not going to do it. Advocating in these courts of law is what you're going to do it, because that's where the asides came from. The asides of court under the asides of Clarendon. They established the court. Why? As a result of the Civil War or the anarchy, which didn't start in England. It started right here with those founding fathers. Okay, so with that, make sure I covered everything. I guess I did. So with that, please understand that many are called and few are chosen. All right. Your king has a civil case and a criminal case pending right now in Superior Court of New Jersey, which, according to Villa versus Harris, as well as the Stanford Oil Company, State versus Standard Oil Company, they clearly says that within your 1776 Constitution and your 1844 Constitution, which is symbolically the United States Constitution, and your 1947 Constitution, they clearly states that the legislative incorporated the laws governing the laws of England, i.e. the political structure or the political under the political science, meaning knowing the science of government under the English government, which is called Written. And that government has not come to fruition till we incorporated in the year 2020 on the record called the public record pursuant to 47:18-1, which they are entrusted with and obligated to protect the expectancy of that privacy right based upon making sure that no trespassing will be done, which apparently they have done. All right. So as your representative, You are obligated to help fight this fight. If you don't, you will be rewarded. And with that, I'm going to greet you and I'm going to meet you as always in peace and love.